My name is Hena, and I work as a senior research data officer within the research data management team. And I'm based at UK Data Archive, which is based in University of Essex. So this session includes presentations and presentation, and you will get the slides after the session, as I mentioned earlier. I will be using Mentimeter throughout the session for the interactive element, which can be accessed using this link and using the code, or you can also take, using the camera on your phone, you can use this QR code to access Mentimeter. So before I begin, please, if you can go to Mentimeter for a couple of questions using this QR code or this numerical code. So I can see a couple of you have already joined. Thank you for that. Just a couple of questions. So just a quick introduction to your background. For example, if you would like to share, if you're a postgrad, early career researcher, or professional services staff, or if you would like to share. So the first one is professional services, research support, postdoc, research librarian, PhD candidate, PhD student. Yeah, so that's great. Qualitative data, someone working for qualitative data, data management, data specialist. Yeah, analyst. So that's really great that we have a mix of people. And I hope that I cover the content that you find useful in terms of your work purposes. So the second question is there any specific aspect of ethics or legal compliance that you're particularly interested in that will help me to update the content of this workshop for the next time, as we do run these workshops twice a year? So that would be very helpful. So genetic data governance, very tricky type of issue to add, but thank you, that's great. Data management and retention requirements, data reuse, data sharing. Yeah, I will be covering data sharing, GDPR requirements, AI in research. Yeah, I am very much interested in this new issue, which is artificial intelligence. So yeah, that is interesting, certainly. Copyright as it applies to data sets and databases. Yeah, I will touch upon very briefly on copyright today as it is beyond the scope, but I will be running, there will be two workshops coming up. One is on next week, which is related to copyright and publishing. It is on Tuesday, and then the following Tuesday, I will be running a workshop on copyright and secondary data use. So you could join that. You can find the link on our events page on our website. So sharing disclosive data, participant consent, copyright, data retention. Yeah, I will be touching upon some of these concepts, and you are very welcome to contact me through an email, which I provide at the end, to ask me if there are any specific questions you have. And yeah, some of the upcoming workshops do cover some of these issues. So final question for now is, what type of data are you interested in or working with? So mixed method. That's great. Some quantitative, some of you qualitative, and some mixed methods. So that is great. Thank you very much. Thank you for your responses. And going back to our presentation, the overall aim of this session is to show you the key considerations in primary and secondary data sharing. The first section focuses on the key principles of ethical research set out by ESRC, which is then followed by the next section on legal frameworks that govern research data. We will also be covering the role of consent, but very briefly, I am running a detailed workshop, in-depth workshop on consent on 6th or either 5th of June. You can check it on our website. So it is with reference to data sharing. And finally, I'll talk you through to the key considerations in secondary data use. I will answer to your question in the end. I know it is a lot of content and a dry content to take in, but hopefully by the end of today's session, you will be able to identify key principles for ethical research. I'm sure you know these already, but just take it as a refresher. And however, I do hope that you will understand the legal frameworks that govern research data, understand the role of consent in research beyond asking participants for research participation, which is the typical role we all know, and specifically in the context of data sharing and future use. Consent has a special role in that. Also, you will understand the key considerations when using secondary data, especially in the context of copyright. As you may be aware that research data is of two types. I'm sorry I've started from the basics as there might be some attendees who need this information. So primary data and secondary data. Primary data is the data that is collected by a researcher directly from the original source through experiments, surveys, and interviews, and observations or focus groups, while secondary data is an existing data gathered from studies, surveys, experiments that have been run by other people or for other research. For example, existing data sets at archives, essays, reviews, or information on social media, and so on. So the first section, which is, it is related to primary data, I will briefly discuss in this section the key principles of research ethics. I will also talk you through some of the ethical considerations and best practices in data sharing, including research ethics self-assessment tool by UK Statistics Authority, which is very useful. So again, a quick question on Mentimeter. If you just would like to go there. What do you think are your ethical obligations as a researcher when sharing your data for future reuse? Any thoughts on that? Yeah, I know everyone is familiar with your ethical obligations as a researcher, but I'm asking in the context of sharing your data. Participant permission, that's right. Protect participants' identity, anonymize data. True. Participants' permission, protection of informants, that's true. Getting consents from the participants, yeah. Protecting the participants and their rights, that's right. Participants are aware that could happen. Yeah, informing the participants. It is itself a challenge as well sometimes. Informing them and maintaining that balance. Making important and unique data available for the use by other researchers, that's right. Making sure it follows the fair data principles exactly. So you are familiar with the fair data principles, that's great. Someone else has mentioned fair as well. Privacy and anonymity. Metadata, complete metadata and rich metadata facilitates data discoverability for future reuse. So that's true. Accurate and complete documentation, exactly. Protecting participants' privacy through anonymity, compliance with GDPR. Yes, that's right. It is a legal compliance as well, but ethically we have to do it too. Original purpose and reuse expectation. That's right. Keep balance between transparency and privacy. Yes, a major challenge. Protection of information. Yes, that's right. Yeah, so lots of knowledge already out there, which is, I think, great. Thank you very much. So, ethic issues are most likely to arise around privacy, equality, diversity, health, and safety, as you already have mentioned. Research ethics govern the standards of conduct for scientific researchers, and it is important to adhere to ethical principles in order to protect the dignity, rights, and welfare of research participants, as some of you have already mentioned that. ESRC has set out key principles for research ethics. For example, researchers should ensure that their research is beneficial to participants, individual, science and society as well, and the researchers should be realistic about the benefits that their research is likely to deliver. Research should be designed and conducted in a way that respects the rights, interests, values, uh, and dignity and autonomy as well of individuals, groups, and of communities. Researchers should inform participants that they have a right to refuse or participate free of consequences, and they can withdraw from the research for any reason, without giving any reason, I would say. And integrity demands that there is a clear fit between what researchers say they will do and how they will conduct their research, and they should be transparent. Transparency means being clear about the nature of the research and communicating this to those involved. And researchers must exercise self-critical responsibility in the planning and conduct of their research. And research ethics committees and research organizations have a responsibility to guide and support researchers, especially when the research involves difficult ethical decisions. And researchers should also maintain the independence of their research, and where conflicts of interest cannot be avoided, they should be made explicit. And by independence of research, I mean that research should be founded on academic credentials, professional standards, expertise, and experience. And it should be free from personal, organizational, and political bias, dishonesty, and considerations of gain. And it should be safeguarded at all times. So it is important that researchers do not just consider what can be done with the data, methods, expertise, and technology available to them. It is equally important that researchers consider what should be done. So National Statistician, I always have a difficulty pronouncing this. So I would use the abbreviation NSTA, Ethics Advisory Committee, provide a framework to help all researchers to think about the ethics of their research at an early stage and give them confidence that their plans address ethical principles and practices. So I've added a link here on this slide so that you can access it. So they have designed a very useful ethics self-assessment tool to review the ethics of the project to be undertaken. This tool enables to identify and mitigate any ethical issues, and it is based on 6 main principles: public good, confidentiality, methods and quality, legal compliance, public view and engagement, and transparency. And you're asked to assess your project against 22 items grouped against these 6 ethical principles on a scale. It is beyond the scope of this session to go into further details of this tool, but you can find it useful. So have a look into it, as I find it very useful. There is another useful resource called Data Ethics Framework by UK government. This is more useful than that UKSA tool. This framework provides guidance on the appropriate and responsible data use in government and the wider public sector. And it helps to understand ethical considerations, addresses these within the projects. And I'll show you a guide available on the website. And again, I have provided a link, and you can access it later on. I'll try to share my screen. This is the data ethics framework and very useful tool. So all the information is there, what is it for, who is it for, how to use it, and the structure. And it is based on these overarching principles and specific actions that covers the entire process of a project. Each section includes questions that will guide you through ethical considerations for your project. You can also go through the description and specific questions to make sure you are adhering to the ethics. And I think it is very useful. So you can see that there is a scoring table here. They describe what transparency is, what is accountability, and then a scale in front of that, fairness. Then self-assessment table for 3 overarching principles. You can score that. Then for 5 of these specific actions, how to score that. Very, very useful tool. And then lots of information in scoring bit. So yeah, that is, I think, quite good. So I cannot go into the detail because of the time constraints. So, but have a look at it. Some of the best practices are that ethical obligations should be considered throughout the research life cycle, from planning and research design stage all the way to the data collection stage, and especially the future uses, which includes publications, archiving, sharing, and linking of data, if you are going to do that. So it is essential to have a knowledge about the standards and requirements of the relevant research organizations. Always comply with the relevant laws, avoid social and personal harm, and you can always check with data centers such as us, who facilitate ethical and legal reuse of research data, protection of participants, and safeguarding of personal data. So this section is all about legal frameworks that govern research data. In the context of data sharing, it would be easier to talk you through about the legal frameworks governing research data if I take a broader classification of research data by Health Research Authority. According to HRA, data or information is broadly classified into 3 main categories: information that relates to identified or identifiable individuals, information that is no longer relates to identified or identifiable individuals, which some refer to as anonymous data, and synthetic data. I'll go through each of these briefly and the legal frames governing. So the first type is information that relates to identified or identifiable individuals. But before that, just a quick introduction to the personal information or data. You can identify an individual through personal information about that person. People can be identified directly or indirectly. Examples of direct identifiers are name, address, postcode, telephone number, voice, picture, and some of the examples of indirect identifiers are occupation, geography, unique or exceptional values in the data, which when combined can identify a person. Personal data also includes special category data that needs more protection because it is sensitive. Personal data includes, for example, racial or genetic data, biometric data, data concerning health, sex life, sexual orientation. So most health research uses special categories of personal data. So yeah, if personal information about people is collected or used in research, data protection regulations apply. And for special category data, yeah, it's more tricky. There are 2 main legal frameworks governing the use of health and care information or research data that relates to identified or identifiable individuals. The common law or duty of confidentiality is the one, and data protection legislation. So these are the two legal frameworks. In the UK, there is a duty of confidentiality that is based in common law, and that occurs where confidential information comes to the knowledge of a person in circumstances where it would be unfair if it is disclosed to others. There are some exceptions when you can disclose information. For example, if participant consents to onward sharing of their personal data, then that's not a problem. Under this common law, you will need to obtain an explicit consent if confidential information is used for a research project. This is very clear and specific statement of consent, and it can be given in writing, verbally, or through another form of communication, such as a sign language. Sometimes public interest can also override duty of confidentiality, and occasionally there are instances when you may need to give up data, such as on a court order. So the best practice is to avoid very specific promises in consent. I'll show you the types of statements to avoid in the end. As researchers, we must adhere to data protection requirements when managing or sharing personal data. So if personal information about people is collected or used in research, then the data protection regulation applies. Data protection legislations that are more widely applicable to the Research or Data Protection Act, EU GDPR, which is now called the UK GDPR. So EU GDPR is the EU-wide data protection regulation that was introduced in 2018 and in the UK, and replaced UK GDPR. It replaced UK GDPR, but now since the UK has left EU, it is now called the UK GDPR. Currently, both UK GDPR and EU GDPR are aligned, and they place the same obligations on researchers. So it is therefore important for researchers to ensure that they gain local support from their university DPOs or their research ethics committees. Mainly, I think university DPOs, research organization, data protection officers, when their research project will span across the EU. So if the researcher based in the UK collects personal data about people anywhere in the world, or a researcher outside the UK collect personal data on UK citizens, then DPA and UK GDPR applies. However, if the researchers are undertaking research projects which span across the EU, then the GDPR will also need to be considered and adhered to. EU GDPR. So the UK GDPR specifies the rights a data subject has when their personal data are processed. For example, individuals have the right to be informed about the collection and use of their personal data. They have a right to access the information you hold, and they can request any change in the information. They can ask for erasure, object, or ask to restrict processing. They can also object in terms of data portability or transfers and any sort of decision making. Which of these rights will be relevant to processing personal data for your research project will depend on the nature of the project, the chosen processing ground, and in which country the research is taking place. So everyone responsible for using personal data has to follow strict rules called data protection principles. They must make sure that the information is used fairly, lawfully, and transparently. Processing should be justified under the lawful basis. For example, when public task is used, ensure that the task should be in the public interest. Processing should not have adverse effects on the data subjects. You should be transparent with the participants by providing them with clear, concise, and comprehensive information. For example, providing information about the purpose of processing, any changes or updates in the research scope, methodology, or data usage. And in addition, personal data should be collected specifically for the intended purposes of the research. It should always be used for specified explicit purposes, and it should be used in a way that is adequate, relevant, and limited to only what is necessary. And information should be accurate and, where necessary, kept up to date and not kept longer than is necessary. That is very important. Most of all, it should be handled in a way that ensures appropriate security involving protection against unlawful or unauthorized processing, access, loss, destruction, or any sort of damage. So under the UK GDPR, there are 6 possible grounds for processing personal data, and one of them must be present. These are consent, public interest, legitimate interest, protection of vital interest, legal obligation, and performance of a contract. However, in the context of research, the first 3, which are consent, public task, or legitimate interests, are the most applicable grounds for the processing of personal data. So just a quick question on the Menti again. If you would like to go to the Menti using these either QR code or this numerical code and would like to answer a quick question. Which legal base have you used or intend to use for your research project? If you have any idea. Consent. That's interesting. I should reframe the question and should ask you if you are a UK-based researcher and if or from you are based in any other country. So which country and which base you are using in that country. So legitimate interest. Nigeria. All right. Okay. That would be interesting if you are using consent or any other. GDPR data protection. EU GDPR. So you are using EU GDPR. Some people are using UK GDPR, data sharing, consent, legitimate interest, Malawi and UK. That's interesting. Human Rights Acts. Okay. Information sheet. So someone in the chat has written can't access Menti. So you based your research on historical and scientific research purpose. That's fine, thank you. And what do you mean by legal base? By the legal base, I mean when you are under the UK GDPR and even under the EU GDPR Data Protection Act, when you have to process personal data. By processing, I mean when you have to collect, store, or share the personal data. You must use one of the legal bases to process it. And the legal basis I have just shown you, I'll go back to the slide. Thank you very much for your responses. I'm going back to that slide. This one. So these are the legal bases under the UK GDPR or EU GDPR or DPA: consent, public interest, legitimate interest, protect vital interest, legal obligation, performance of a contract. One of these must be present when you process personal data. Either you obtain a consent from the participant to process their personal information. If you cannot obtain a consent, then you should evidence or prove that it should be in the public interest. That is why you are processing personal data, or it should be there is a legitimate interest to process personal data, and so on. So by legal basis, I mean this. So under the UK GDPR, one of these reason is a common term you can use for legal base, just to explain you that one of these should be present to process personal data. So I ask on the Mentimeter which legal base you have used in your research. Some says that they have used consent. Some have mentioned that they have used legitimate interest. So yeah, that was the question based on this slide. So in the UK, Information Commissioner's Office advised that for almost all research conducted in the UK organizations should rely on either public task for all bodies, for public bodies such as NHS, higher academic universities, UKRI, research organizations, and so on, or legitimate interest for non-public bodies such as charities, commercial companies, and so on. However, those holding and using health information, which is a special category of personal data in GDPR, will also require a further condition in addition to the public task. In academia, this is usually to support scientific and historical research, as someone has mentioned in the chat that they are using scientific and historical research. So in academia, the additional condition is always scientific and historical research purpose. And for the special category data, you may also need to complete a data protection impact assessment for any type of processing which is likely to be high risk. So you must therefore be aware of the risk of processing the special category data. So there is a misconception that data protection laws such as GDPR prohibits data sharing. However, it does not prevent data sharing as long as you approach it in a sensible and proportionate way. GDPR is useful for research because it legalizes much of the current good practice in research, placing people at the center. And it offers enhanced rights to individuals whose data is being processed. And in the context of research, it has the potential for further benefiting research and archiving, helping to improve trust and confidence between the public and universities and between researchers and their participants. So this was all about the data that can be identified or identifiable. If you remember, I have mentioned that there is a second type of data that no longer relates to identified or identifiable individuals. This is the data that has been anonymized or pseudonymized. Personal data that has undergone effective anonymization is not, however, regarded as personal data and therefore not subject to the UK GDPR. This is because the data has been modified and is no longer relates to an identified or identifiable individual. There are several anonymization techniques that can be used, for example, aggregating, suppression, rounding, reduction in detail, and so on. It is beyond the scope of this session to talk through these. However, I've added links at the bottom for you to have a look later. And I think one of my colleagues is running a workshop on anonymization as well, which you can check on our events page. Or maybe she has done that, so you can access our past events on YouTube channel. So coming back to this, data that is treated in this way is no longer considered confidential and generally speaking does not fall within data protection laws. And but it is important to note that even when data is anonymized, it may still be possible to find ways of identifying your individual or personal information. However, it would likely require special circumstances or effort. This effort may involve using other sources of information to narrow down the number of individuals that the data may be referring to. But this is debatable whether you can achieve effective anonymization or not. On the other hand, pseudonymization is a security enhancing process that replaces or removes information in a data that directly identifies an individual before that information is shared with a third party. For example, it could involve replacing an NHS number, name, or address with a unique number or code, which is called pseudonym, with the effect they are identifying an individual directly from their data is not possible by the recipient without additional information. For example, the key that would enable matching the pseudonym back to the identifiers in the data. So personal data that has undergone pseudonymization but could still be attributed to an identifiable individual by the use of the data alone or in combination with other data likely to be available is legally presumed to remain personal data under the UK GDPR. So more information is about these topics at the bottom of the slide. And then the third type is synthetic data, which is information that is artificially created rather than generated by real world events. It can simulate synthetic populations that resemble the characteristics as well as diversity of actual people. And it can also be generated to be statistically consistent with a real data set, which it may then replace or augment as synthetic data is neither personal data nor confidential patient information. It is not subject to data protection legislation or the common law or duty of confidentiality. So this section focuses briefly on the role of consent in research. I'm sure you all are familiar with what informed consent is. However, when it comes to data sharing, then consent is used for two purposes: to fulfill ethical obligations and to be legally compliant. We are all familiar with the consent that is used for research participation and is considered as one of the founding principles of research ethics, where it is sought before participation in any research activity and from all the participants. And you all know that it usually involves providing information regarding study purpose, risk, benefits, voluntary participation. However, as stated earlier, consent can be used as one of the legal basis or lawful basis for processing personal data under the UK GDPR. If you remember those 6 lawful bases, consent was one of them. If a researcher collects, manages, and share personal data, then consent of the data subject can be used as a legal base to process this personal information. But as mentioned earlier, in the UK, it is rarely used as a legal base in research context, though not mandatory under the UK GDPR, but you should obtain an explicit consent under common law or duty of confidentiality when you have to disclose or share confidential information for research purposes. For example, under Human Tissue Act or for clinical trial purposes, you need to obtain explicit consent. That is another thing. Therefore, consent plays a vital role to be legally compliant, especially when it comes to being transparent, fair, and maintaining confidentiality. So in the context of data sharing, consent, you can say that we use public tasks, but to obtain consent is an ethical obligation where you inform participants what you are going to do with their information. For example, you are going to archive their data, which is then used by other researchers in future. So that should be the obtaining consent is the ethical responsibility. Consent can be gained in written or oral form, and the format of the consent depends on the kind of research. However, it is important that whatever format is used, written or verbal, it should be documented. You need to document how it has been gained, what information has been provided, and what the participants have agreed to. So consent forms play a vital role in data sharing, and it is very important that you design the consent forms, keeping in mind these 3 important sections in the consent form if you plan to share your data. The first section should be about taking part in the study. That includes some basics, such as participants have read and understood information about the project. They have been given the opportunity to ask questions. They understand that they can withdraw at any time, and so on. And the second section is all about how the information that is being collected will be used. For example, how the data will be stored, for how long, how the confidentiality will be maintained. And the final section should be around providing information about future uses of the data, such as publications, archiving, and so on. The final section is really important if you are to share the data for future by other researchers. So, yeah, I'll go through these in details in my workshop that I am running on 5th of June, I think, which is on consent issues in data sharing, where I will go into details showing you the sample consent forms and sample statements in that, if you would like to. So, when you start a research project that involves collecting information from people, for example, via a survey, through interviews, focus groups, video recordings, then these questions can help you to comply with data protection legislation in practice. The first consideration should be whether the project needs to collect information that would be defined as personal data. If not, then do not collect it. If the research does not collect personal data, then data protection legislation will not apply. If personal data is being collected, the researcher needs to identify who will be the data controller for this collection, storage, and handling of the data. This is unlikely to be the researcher themselves, and in most instances will be the researchers, universities, or institutes. So if the research involves collaborations of different partners, it will be important to identify whether they will be joint controllers of the data or data processors. It will be crucial to ensure data sharing agreements are in place, and where necessary, processor controller agreement. The data controller is the person who determines the purposes for which and the way in which personal data is processed. By contrast, a data processor is anyone who processes personal data on behalf of the data controller. So just for an example, if you deposit data with us at UK Data Service, you are the controller and we are the processor as we process data on your behalf. And you are the controller. You are going to define what you are going to do with the data. So an assessment will need to be made about the most appropriate processing ground to use for each research project. And as I mentioned, there are three grounds that appear most applicable for research: consent, public task, legitimate interest. And if you are using consent as the processing ground, it is crucial that this is distinguished from consent for other ethical and legal purposes. And that participants can withdraw their consent for processing personal data. This should be mentioned in the consent form as well. And bear in mind that this is different from the right to withdraw from the research. So all these nitty-gritties of consent, I will go in the next workshop I'm carrying out. Because to go into details in this session is just beyond the scope due to time constraints. So the information that needs communicating will be influenced by which processing ground is chosen. Broadly, participants should be informed about how any personal data collected about them will be used, stored, processed, transferred, who the data controller is, as I mentioned earlier, the legal ground, purpose of processing, any recipients of the personal data, period of retention, and their rights. Including that they can complain to the supervisory authority. So all these questions will help you to determine if you are handling personal data. So remember, despite all the information I have gone through, bear in mind that much research data, even sensitive data, can be shared ethically and legally. Researchers employ certain strategies, for example, offering protection of identities through anonymization, using processing ground for personal data, regulating access where needed for all the data or part of the data, and finally, regulating access to the deposited data. Yeah, I think, yeah, I have mentioned some information on regulating access. By regulating access, I mean that if you restrict access, it facilitates data sharing, especially when it is not possible to anonymize data or to obtain consent for data sharing. In that case, you can restrict user access. For example, at UKDS, we facilitate 3 levels of access for data. Open access for data that contain no personal information, safeguarded access for data that contain no personal information, but the data owner considers a risk of disclosure resulting from linkage to other data. And it is available under end user license, and users need to register to access data. Users also need to agree to certain conditions, such as not to disclose any identifying information if they find it. And finally, the controlled accesses for the data that may be disclosive. And controlled data are only available to users who have been trained and accredited, and their data usage has been approved by the relevant data access committee. And access is through a virtual or physical secure environment. So access varies according to user type, location, data access condition, and project type. So now the final section. It is about what needs to be considered if you are planning to use secondary data sources. And yeah. So 2 most relevant types of rights applicable to the secondary data sources are copyrights and database rights. I will talk you through to copyright, which is most important and applicable due to the time constraint, and I have added a link at the bottom for other rights for you to have a look. So copyright or IP rights are assigned automatically to the creator or the researcher who owns the data. When data are shared or archived, the original owner retains the right. Data archive cannot archive data unless all right holders are identified and give permission for their data to be shared. Copyright applies as soon as the data is created. You are the copyright owner of the data that you share for the future use by other researchers. And in the context of primary data, if you plan to share it for future reuse, you need to consider how you want your data to be used by other researchers. So you can specify this by licensing the data to match the intended usage. And various types of licenses for sharing data have been developed by the data archives. As I showed you earlier, the licenses I have mentioned the end user license that we use at data, UK data service. But I'm unable to go into detail of the end user license. If you are interested, you can read about it on our website, or you can contact me afterwards through email. In the UK, copyright arises automatically once a work is created. To enjoy copyright protection, the work must be original. That is to say, it must be your own work, not copied from someone else. And there is no copyright in ideas or facts, only in the way those ideas are expressed, such as diagrams, tables. And so I have added a scenario so that you can have a better understanding. Before I go to that scenario, I am also running, I mentioned earlier, I think that I am running a copyright workshop on copyright and secondary data use in 2 weeks' time. So I will go into more detail in that workshop. If you would like to join, you can. So yeah, if you would like to go to the Mentimeter, I have put that scenario over here and with those questions to get your responses. So this is the scenario underneath this question. A researcher studies how health issues around obesity are reported in the media in the last 10 years. Freely available newspaper, websites, library resources are used to obtain articles on this topic. Data includes articles and excerpts. And the question I asked was, can a researcher use public data without breaching copyright? Yeah, so most of you have said it depends. Yeah. Yeah, so I would say those who have said yes could be right if you are not planning to share that data for future reuse. You are not depositing it in an archive, then that would be yes. But if you are planning to deposit it or share it with either, I think some journals might require you these days to deposit data with them, or some funders are making it mandatory to deposit your data somewhere after you finish your grant, then I think the best answer would be it depends. So it depends what you are going to do. And basically, even though the articles obtained are in the public domain, they are still under copyright. While such information can be used for personal research purposes, the articles cannot be archived unless you check the permission for future reuse associated with them. If they are under copyright, then you need to obtain that permission uh, from the source. Otherwise, you are unable to uh, archive it or share it with any third-party organization, journals, archives, so on. And the second question I asked was, can the data be archived and shared with other researchers for future use? Yeah, so I think I have already mentioned the answer to this, and you have already answered that it again depends. Yeah, that is fine. Thank you for your answers. So if you are using secondary sources, then best practice is to assess who the copyright holder of the data set is. Are you allowed to use them, and in what way? Are you allowed to archive and publish this in a data repository? Most of the time, we encounter problems when researchers are allowed to use data as the data is under open license, or they register to use it, or it is under paywall. What they do not realize is that it is accessible to them for their own use, but they need permission from the data owner for sharing it and archiving it. So you may need to seek further permission to distribute material you do not own. If permission is not granted, you need to remove copyright variable or material before publishing or sharing it. So to be legally compliant, always investigate early which laws apply to your data, including cross-country collaborative working. Do not collect or keep personal or sensitive data if it is not essential to your research. Plan early on, seek advice from your research office. Ensure that you check participants know how this data will be used. And remember, not all research data are personal. For example, anonymous data. This is a useful slide. I have added a link to this variable information log for those who are using secondary data. It is a useful template, and it is called variable information log for data sets being deposited that include secondary data sources. Researchers are advised to prepare a variable information log describing these resources. This allows others to understand and use data correctly And it also ensures that repositories can check the appropriate terms and conditions applicable to onward sharing of the data. And this log should include the name, variable name, its source, how it was collected, brief description, any restriction on its further use. So I have added a link. And these are some of the resources, useful resources for you to have a look later on. And these are the links to our training and events page. And you can register for the UK Data Service using this QR code. And then a quick quiz at the end if you would like to join for that. Just a quick quiz. You can go again to the Menti. So what do you think? Effectively anonymized data is not subject to the UK GDPR. Yeah, that's true. Yeah, because if you are sure that you have effectively anonymized the data, then it is not subject to data protection regulation. Thank you. And what do you think if the researcher based in the UK collects data outside the UK GDPR does not apply? Yeah, that's false because if you are based in the UK, then UK GDPR applies even if you are collecting data on from another country, then UK GDPR does apply, and also the applicable rule in that country applies to you. So that's false. That's that's correct. Data protection legislation still applies if there is no personal information in the data. I think that's too simple for you. Yeah, uh, I think it's false because it does not apply. If there isn't any personal information, then it does not apply. Any data protection may be somewhere else, but in the UK it does not, and even in the EU. So if the researcher based in the UK collects data from the EU, which of the following applies? Yeah, that's correct. Yeah, both EU GDPR and UK GDPR both applies because the researcher is based in the UK, so he or she has to adhere to the UK GDPR, and the researcher is collecting data from EU, so EU GDPR also needs to be considered. Thank you. And how can you share sensitive data? Any thoughts? Encryption? Yeah. Anonymization? Yeah. Share metadata only when, yeah, we would advise when there is no option left, you cannot anonymize data. For example, in qualitative studies, if you effectively anonymize data, you may lost quality data. There is no useful information left in the data, and you could not obtain consent. you cannot anonymize, you cannot regulate access. So then, yes, we advise to provide rich metadata. Informed consent, closed access repository. Yeah. Appropriate access level. That's right. Yeah, these are the strategies that you can consider when you want to share sensitive data. Yeah, so informing participants about the future uses of data is an ethical obligation, a legal obligation, or it depends. Yeah, it is an ethical obligation. Yeah. Yeah, it depends is also true. If you are not sharing that data and you are collecting it for your own research purpose, then yes, it depends whether, but as ethically, you should inform if you are planning to share it, what you are going to do with their data. Yeah, so somebody, I think, comment that what about new future users? So it is an ethical obligation because as I have gone through, informing participants about the future uses of data is not a legal obligation. It's an ethical obligation that you should inform the participants. I'm sorry, a comment did appear and it just disappeared. I couldn't read it. So freely available information online does not have any legal implication in the context of data sharing. That's false. Yeah. It is false because if you are planning to share that information, then it has. If you are sharing it without obtaining copyright permission, if it is under copyright. No, somebody did write unless in public domain. Yeah, that's what I have gone through in that scenario, that somebody has collected data which is already in the public domain from freely available newspapers or social media. Um, Data in the public domain does not mean that you can, there isn't any legal implication. You can use it for your own purpose, for your own personal use, but when it comes to data sharing, then it does have legal implications. You need to check the source, the terms and conditions associated to that source. If they allow you to share it with other researchers for future use, then that is fine. If they don't allow it, it is under copyright. Then you need to obtain permission before you share it. So the information in the public domain does not mean that it does not have any legal implications. So this is about the consent statements that I referred to earlier. Most of the time we encounter such statements that are being used in the consent forms, that any information I give will be used for research only and will not be used for any other purpose. Is this statement appropriate? If you are to share the data, if it is mandatory by the funder to share that data in that case. Yeah, it is too broad and vague. Because if you are planning to share that data, such statements are vague and they does preclude data sharing. You should avoid such statements. So this is not appropriate in the context of data sharing. There is another statement that we see every now and then. I understand that only the research team will have access to the data I will provide appropriate. We understand that by using this statement, researchers might mean personal data. Only the research team will have access to their personal data, and anonymized data will be shared with the third party. But this statement is again very broad, vague. You need to be clear, and such statements preclude data sharing. And the only advice we are left with, just go back to the participants and ask for retrospective consent, which is, I think, not possible in all in most of the cases, majority. Yeah. Another statement, all research data will be destroyed after so and so years appropriate. So here it should not say all research data. You should specify whether you are mentioning about personal research data, personal information you are referring to, or is it all research data? So this is again inappropriate and preclude data sharing. So such statements or wording, it does matter when it comes to data sharing. So always design your consent forms very carefully, especially if your funder requires you to share your data. I think that is all. Thank you very much for your responses. And thank you very much. I understand that this is a lot of content to go in just 90 minutes and to take in 90 minutes and understand everything. It's just to give you an overview. You can always email me with your specific queries, project related queries, and I am happy to answer that.